You are listening to the Unusually Well-Informed podcast.
Welcome to the Unusually Well-Informed podcast. I'm your host, Tim Hampton. My unusually well-informed guest today is Sharon Hartung. Sharon is a retired aerospace engineering officer from the Royal Canadian Air Force and former technology executive from IBM. Sharon is the author of the book titled Digital Executor, Unraveling the New Path for Estate Planning. The last gift you'll leave your loved ones now has a growing digital component. Today, Sharon and I will talk about estate planning for both our physical and digital assets. Sharon, welcome to the show.
Thanks so much, Tim. Delighted to be with you.
It's my pleasure. One thing that struck me as I was reading your book is that making your last intentions known is an act of kindness to those you leave behind. Can you talk about the importance of leaving a well-constructed will?
Absolutely. As you can imagine, Tim, I think of things in project terms. So maybe I'll start there as a bit of an analogy to estate planning, because the term estate plan or estate planning or will is, we all understand what a will is, but many of us, including myself, didn't really understand what an estate plan was. So if you think of a project, you would pick a project manager, you would identify a scope, you would check in with the project manager to make things are going well. And we use projects and the basis of project management in many aspects of our lives, whether we're renovating something in our homes or whether we're doing something in our business. So the most interesting thing about our wishes as it relates to will and estate planning is we're leaving behind somebody in charge of our closing down our lives, which is called the executor or estate trustee in some provinces. So the most common estate planning document that most people would be familiar with is a will, in which you outline what your intentions and wishes are for your beneficiaries in terms of what you own. And obviously the most important thing about a will is considering those beneficiaries and your loved ones. So what's really, I find really fascinating about the topic of will and estate planning is we think about, yes, I got to get a will done, but we don't often think about the conversation with the person who's the project manager, who's going to be left behind to execute on those wishes. And now in the digital age, it's even more important because we leave less of a paper trail. So there's more need now with our digital lives to have a conversation with the executor. I know that's a bit of a longer answer and it's more project management based, but I find those are the kinds of analogies that people understand versus the technical words that come from the estate industry.
Well, it's definitely a reminder that we have a deadline, and
we have
there's
a
no
deadline.
choice about that. So I appreciate that. What your book is titled Digital Executor. What inspired you to write this book?
What inspired me to write this book is, my first book, Your Digital Undertaker, I wrote after my mother died without a will. And I became aware of the role of the executor, this project manager that you leave behind to execute on your wishes. And, I'd run some big projects during my career. And I felt like a junior project manager, not knowing what to do when my mom died, even to know what her wishes were for funeral arrangements, and then obviously to address her estate, which is made up of her traditional property rights, like her bank accounts and her properties, etc. So I was inspired to write the first book because I didn't realize how big this executor job was. So the first book is about the impact of our digital lives on our personal estates. And to understand how do we manage our digital lives in estate planning, we need to know a little bit about estate planning because there's some terminology there. There's the role of this executor that I talk about, some estate planning terms. So I cover that. So digital assets in the context of the estate industry. And what I became aware of as I worked through the first book and began to set up my own business in the technology management of digital assets and estate planning is that service providers that we rely on to provide our digital platforms and our digital lives are not as aware about their customer needs, that we will want beneficiary designations for our digital assets, and we need to be able to consider these things. In fact, I was very compelled by a study out of Aston University. It was Queen Mary University in the UK. I met a researcher there whose name was Dave Michael, and he and Christopher Millard wrote a study looking, they had a project called the Cloud Legal Project, and they looked at terms of service providers, and you can imagine how much work they must have had to do that.
Like
And they
looking at
found that
credit card terms of service. Yeah.
Exactly. So they looked at a number of what they call cloud service providers. So those are general platforms we use. And 85% of cloud providers did not address incapacity and death in their terms of service. 100% of service providers did not allow password sharing. So it really struck me in terms of the need that we need a conversation with service providers. We need a conversation with online businesses. So the second book is about digital assets in the context of the digitization of the estate industry, which is now unfolding. And it's a message for not only advisors about how to start tackling this with their clients, but the industry that supports all of us now is going to have to address this.
So what are the types of digital assets we need to consider when estate planning?
I think to look at, a lot of people have categorized digital assets in a number of different ways, and the term itself is not very user-friendly. So let's start with the basics of the term. I like to say digital assets are our memory, our money, and our records. They're just now in digital form. And clinically, if you want a clinical definition, they are electronic records. And these electronic records, as we consider our estate plan, we have we might own some of these electronic records. We might have rights to some of these electronic records, or some of these electronic records may be governed by terms of service providers, but we need to consider them. The Society of Trust and Estate Practitioners, which I'm part of, which is a global organization of estate practitioners, developed a digital asset inventory to help advise the clients to start talking about digital assets. And in fact, version 2 we wrote for tech entrepreneurs because the volume is starting to get big. And we had 3 categories in there. We have digital assets as pure assets, things like our social media, our email, our digital photos, our crypto assets. And then we had digital assets that provide access to underlying assets. So things like our bank accounts, they're governed by, other things, but the digital asset part is the access. We go online and we have a intangible asset underneath it. So there's some more complexity to that. And then digital devices, which are the physical, devices that we use to actually access the internet. So things like our laptops and our iPhones. So there's 3 big categories, and it's amazing. When we wrote the version 2 of the inventory, we're up to 20 pages of various kinds of things that we have, which can be overwhelming. And so I often reflect to advisors or clients to say, it's not unlike your own home where you may have quite a list of physical items in your home. You're not likely to create an entire list of everything in your home and define your wishes for them. You're going to pick the most important ones. So we can do that with our digital lives too, in terms of, I encourage people to think about the top 3 digital assets that they would be devastated if they weren't transferred. And some of these things are things we do every day and we care about. Loyalty points. Clients are quite passionate about those. We might have somebody in mind that we'd like our loyalty points and the reward points because we collect a lot. In fact, one of the stats that I keep reminding myself of when I think of loyalty points is CBC did an article about loyalty points a couple of years ago. And apparently Canadians are hoarding $16 billion of loyalty points. Now, it's not all deceased people, obviously, but we certainly are collecting a lot of them. It could be our photos, right? We do everything online now. It would be devastating if people didn't have access to those. So, I can encourage people just start with those, try to find the 2 or 3 things that are really going to matter and look at the terms of service, start to address how it might leave them behind. And then, then back your way into the bigger list if you have more.
One of the things you did mention loyalty points in the book as well. And I'm fascinated by the idea that they survive your death. Is that universal or is it only for some cards? How does that work?
That's a really good question, because what happens to your loyalty and reward points upon death is completely governed by what they call the provider's terms of service. So if you have one, you'll have to go look it up, because some of them do terminate on death. I've written a few articles about my Canadian Tire points. I was a big fan of collecting Canadian Tire paper money, not to date myself, but their reward program does not survive death. It's not transferable on death, which is unfortunate. And, I generally say, well, I can't believe there's no Twitter outrage, probably because consumers are not aware. They just assume all the loyalty programs work the same, but they don't. You have to look at the terms of service, and you have to determine if they are transferable or not.
Not to put you on the spot, but just out of curiosity, the granddaddy of them all is air miles. Do you know if it's transferable?
I would have to look it up again.
Okay,
I do
fair
believe
enough.
it is, but I
Yeah.
haven't checked in a while. So,
Yeah.
and
that's the other thing too, is of course it keeps changing. So we really have to be on top of that.
right. Some of the digital asset vault vendors out there, a few that I'm aware of, I know that they often check every 90 days because terms of service do change over time.
Wow. You mentioned earlier that I think you said 100% of the platforms you looked into, or the group looked into, don't have provisions to allow us to use somebody else's login.
Right.
And
Password sharing.
it's hard enough. It's hard enough when somebody passes, and at least they left a book full of passwords, which has its own security risks involved. But at least we have something to go on. It's like that the idea that you were saying in the book, that pretty much everybody, 50 years ago had a filing cabinet full of everything the executor needed. Now it's, where is it? It could be in the cloud, it could be on their phone. It reduces the executor to a hacker almost.
Yeah.
How do you get around that? Are there ways that we can say in the will what we want the executor to be able to do?
Yes, it's a complicated issue, but let's try to unpack it. While we're living, as we know, password sharing is against pretty well all terms of service. There may be 1 out of a million that doesn't allow it, but for cybersecurity reasons, and as you've stated, and as I've stated many times, it is putting your executor in the position of hacking if you leave your passwords behind. Some people think that leaving passwords for their executor is different than leaving passwords out for a friend. No, it's not. Password sharing with your executor is still password sharing, and the Queen Mary study basically determined that 100% of service providers do not allow password sharing in their terms of service for all the cybersecurity reasons that we know. Now, if we were allowed to password share, I sometimes take people down the technical or practical aspects of that. We know for cybersecurity reasons, we have secondary authentication methods that we use, and a variety of them, either two-step or secondary authentication methods, right? There's a lot of AI being implemented around cybersecurity today to determine where you're logging in and how long since you logged in last time, right? How many times I've gone to one of the 2 coffee apps on my phone to have myself logged out during an update, right? So you got to log back in. So I think the ability of us to even use passwords is not going to be there. It's a practical issue, right? What if an update of an application happens after death, and then suddenly that app doesn't work on that device anymore? So I think there's a real practical aspect. Now, having said that, we're the first generation to deal with transferring our digital lives, right? So it shouldn't be a surprise. And a lot of people do leap to saying, well, I should use a password manager, because the technology industry does recommend the use of password managers to help us keep long, complicated, different passwords for various accounts. Password managers are for the living, and they're a great way to sort of tidy up our digital lives. And you also hear the tech industry tell us to, try to reduce the number of digital accounts you have. If you don't need them anymore, get out of them. Also, revise your privacy settings on a regular basis to make sure that you consider that. So let's now turn to this challenging role the executor has. So we're in a space right now where it is very challenging for the executor. There are very few service providers that provide pre-planning options. Now, pre-planning options is just a term the estate industry uses to say, what can we set up prior to death or incapacity while we're living? So you won't find pre-planning as a category in service provider accounts, but I'll give you 3 examples, and then we can talk about what some other things we can do. Facebook was one of the first. They came out with a pre-planning tool, and basically how it works is you decide if you want your account deleted on death or if you want it to be memorialized. And a lot of people are now familiar with that. You go into settings and you're looking for legacy contact, and you can set it up. Now, the questions don't work out the way when you go in there. It basically asks you first, do you want it deleted? And if not, do you want it memorialized? And then you select a legacy contact. The other big provider that has pre-planning function is Google. Google has inactive account manager. It works differently than Facebook. You can select an inactive account manager, and you're also given a period of time between 3 months and 18 months in which your account, if it's inactive, will trigger that individual to be provided access. And, they have some procedures to do that. And then the third big one that has announced pre-planning options, they call it their digital legacy program. And I think they're going to use the same words as Facebook, being a legacy contact, is Apple in their announcement. So that should be coming out, I believe, in ISO 15 in the fall. Again, it will allow you to select somebody who will be your legacy contact and will have access to your data. So long-winded to get here, Tim. Maybe I'll just pause and see if you want to take it in a different direction, and then I can make some more comments about how we can plan in advance.
Well, certainly. I appreciate you pointing out the Google and the Facebook. I've actually done that because you prompted me. So thank you for that. And among my many fans on the show are my sister and my mother. So hint, hint, right?
Yeah.
And it's fascinating to see that it's being extended. But as you point out, it's a very rare exception. Hopefully a trend, though. Would you say that's happening?
I believe so. I think it is significant that the big tech giants have weighed in and started to provide pre-planning. So Facebook, Google, and Apple now. There are limitations to these tools that people have to be aware of. So one thing I point out on Facebook that's relevant is your privacy settings during life become frozen on death. So I do encourage people to lock down their privacy settings for their personal accounts. And if they truly need to have an open account, get a second one for whatever purpose you're using one for. Because after death, once your account's deleted, obviously, or once your account's memorialized, you can't change the privacy settings. So if they're open on life, they're open on death. If they're closed on life, they're closed on death. Google's inactive account manager is kind of interesting because, they don't contemplate death per se or incapacity. They contemplate inactive period. So in some
Google users
respects,
never die. We just fade away.
We just fade away. And in effect, it helps address both of those planning considerations. So it'll be interesting to see once Apple comes out with theirs. Now, for everything else, and it was one of the reasons I wrote the second book. The second book was written not only for advisors, global advisors, but for the tech industry and businesses. All online businesses, including ones that provide loyalty points, will have to consider these client requirements. In fact, I wrote an article with Jennifer Ziegel, who's a lawyer out of Philadelphia, for Bloomberg Tax Insight around the options that we feel that we should be provided. So consumers, yet the marketplace demands is still there. So, this will at some point in the future, I believe, become a competitive necessity to have. It could be all sorts of the different mechanisms we use with our traditional or physical property rights. Maybe there's a joint accounts, which we don't currently have. Maybe there are beneficiary designations. They might be called different things. And you could argue these pre-planning tools are kind of like beneficiary designations. Now, so where does that leave one when with everything else? With everything else, we have to consider two things. One is we may have pure digital assets like crypto assets and other things that we really truly have to sit down and start to plan through. So Pamela Morgan wrote a tremendous book called Crypto Inheritance Planning in terms of how to address those kinds of crypto assets. If it's our loyalty reward points, again, our executor or fiduciary should not be logging into our accounts. They should be checking the terms of service and contacting customer service to facilitate the transfer if the terms do allow. Now, there's other things we do online that are either intermixed with our lives. So, for example, if you're writing a book, you're probably using some documentation processing, and it's probably held in a cloud account somewhere. So we'll have to start to consider the planning requirements around them. Perhaps we leave a printout. Perhaps we burn it on a DVD. Not to date myself, I still do that. Or ask those providers if there are facilities so that they can be transferred. So that's where our traditional property rights, like our intellectual property, starts to mirror with our digital life. And then we may have other digital assets like web domains and other things, or even Facebook accounts we might use for small businesses. I'd say the pandemic has accelerated everyone online. And it accelerated, all these small businesses and things that we do online. So the good news is, for small businesses or any kind of businesses, A lot of providers have business functionality. And if you use the business version of the account versus the personal use version of the account, and I'm being quite generic here, there are administrator accesses and other things that you can do to facilitate secure access for another person. And I think those need to be contemplated as part of the planning. And again, you have to wrap some legal documentation around these things so that there's a reason why someone was given an administrator access to your web domain. So, for example, to facilitate transfer. So it's a bit of, packing an entire book in 5 minutes of a summary,
Yes,
but that's
it is a lot.
where we're going.
One of the things that strikes me is all these platforms have been created, certainly in our lifetime, you and I. And so we're going from 0 people affected by death in these platforms to eventually 100%. Everybody 100%. Is going to encounter this issue at some point. And so I applaud the advocacy you're doing to get these platforms to at least think through. And I like the approach you're taking of saying, okay, look, you're able to do this for businesses, contemplate that that no person is an island either, right? That they need to have an administrator after death. But one of the things I wanted to bring up and check with you on is, okay, so we've allowed for example, my executor access to my Google account. I still need to express in my will what I want him or her to do, right? Like there may be things in there I wish to continue publishing, drafted works I would be fine with somebody completing, but I still need to express it. There's no technical mechanism to take care of all of that, right?
Correct. You still need to document your wishes and preferences for everything that you feel is of value and you want transferred. And how you do it is where people should go and get some legal advice. In some respects, you can address some of these things in a will. Certainly, within each of the individual provinces, some of the law societies have been publishing digital asset clauses that give the executor guidance on how to deal with the pile. In my opinion, from a technical management perspective, it's not sufficient because it doesn't give the specificity, right? From a technical management perspective. So it may give them permission to address your digital assets, but it doesn't tell them what to do with specific ones. You may have significant digital assets. I define significant digital assets as kind of a standalone little ecosystem. Even if you think of having a hobby and having an Etsy account, people think, well, it's just one account. Well, it's not just one account. As you know, you'll have your Etsy login, you'll have your email associated with your Etsy, you're going to have perhaps a financial intermediary, maybe it's PayPal, and then suddenly you've got Facebook associated with that, and suddenly you have an ecosystem around whatever is significant to you. So what I encourage people to do from a technical management perspective is document what that is, right? In technical words, we would say, what's the architecture of it, right? So how many different accounts make it up? What accounts have you used? Is there a business version of the account? I believe I've checked Etsy before and they only have one kind of account and it doesn't allow transfer of the assets. So if you have intellectual property associated on there, again, you're going to have to consider how to back it up. But the industry will have to consider these things in the future. And I think the marketplace will demand it. We have 2 roles we have to consider. One of the person making the wishes and preferences, either as the testator or a will maker, or as somebody who could potentially become incapacitated. And then we have the second job of the person who will step into the shoes of the individual and need to address it. So there's a bunch of different things there, right? There's the what am I going to do practically? And then what do I need to get papered from a legal perspective? And we may have a lot to deal with that may be addressed, maybe pointed to in the will. So you could put your specific web domain in the will, and you could, your wishes could be stated in terms of who you would like to have it. But you may have to provide other documentation outside the will to make sure that happens, because you'll have to consider things like situs, like where is the provider that's providing that. Again, there's so much in there, and it's hard to give just a general answer, but. And then the third consideration is the tax implications, right? Mm-hmm. So just like we have assets and we need to leave a paper trail in terms of the cost base, so that our executor or fiduciary can do the taxes upon death. The same thing applies to valuable digital assets, whether it's web domains. Web domains are unique in the sense of you generally pay every year, like a subscription service. You don't just You may have bought it outright from somebody else, but where is all the documentation to support those kinds of things when you start to think of it from a valuation point of view?
Yeah, if you saw the blood drain from my face, I thought about the example you were giving, and you're right. There can be so many ancillary accounts associated with any activity online that it's kind of scary. It's a lot to think about.
And if I could offer one sort of perspective is, in our workplace or our small business, we think of, having an IT department or outsourcing IT, and it's all taken care of. In the last 30 years, we've really brought IT home, right? And who is our home IT?
Right.
And I think that's why there's sometimes a misnomer that we should just get some random person to look after our digital lives, because we are probably relying on a friend or family member to help us with our digital lives, right? Sira.ca had a very interesting statistic in 2019. They said something like 45% of people are providing tech support to other people, right? Which is fantastic. But I think we're going to have to consider providing ourselves a little more robust home environments and consider how we plan and document what we do in our home and lives if we truly want these things transferred after death or incapacity.
One thing I wanted to speak with you, I don't know if this isn't exactly within the scope of what you're doing, but it is possible that we will need to make our needs known when we're simply incapacitated. Do you have any advice on how to deal with that while we're still alive, but we're unable to attend to our own affairs?
Right. The way the estate industry looks at that is they generally call that advanced care planning. So there are legal documents you can put in place to, again, not appoint an executor as you would in your will after death, but you can appoint someone to represent you while you're living. So there's two main kinds of documents to address incapacity. There's a document for your personal care, and that document has a different name in every single province. So in Ontario, it's called the Power of Attorney for Personal Care, and in British Columbia, it's called the Representation Agreement. And you are appointing someone who will act on your personal and health care on your behalf and provide instructions if you're incapable of providing instructions. The second document is generally known in Canada as the Power of Attorney for Financial Affairs. And that gives a fiduciary, which is often called an attorney, where you appoint an attorney, not to be confused with the US who call lawyers attorneys,
right.
But you appoint someone to be your attorney who then can act on your behalf in financial matters. So your power of attorney for financial affairs should also include instructions about your digital assets. It may include the same kind of clause that you have in your will, and additional documents and planning may be required as well outside that document. And this, the conversation needs to happen with that individual, whether perhaps you've selected the same person as your executor and not. So we have a little cleanup to do, I think, from our digital lifestyles that we have in terms of being prepared for those circumstances, right? So even things like, if we take the web domain, which I know you probably have one, most web domain providers, registrants as they're called, if you log into your account and you go under your account profile, there are administrator accesses that are often granted because they do consider this most often in the business context. So that's a good opportunity to get that updated, giving someone else secure access. Again, not sharing passwords, but setting them up with their name and recognizing them as having administrator access. And some web domain registrants let you pick all the different things that they can do or not do. Like they can transfer domains or they can't, and they can pay the bill, they can't. And then you'll want to wrap some paperwork around that as you do your estate planning. A legal advisor can tell you which document it's best to put in and how to put it on paper.
Many of the platforms that you're talking about are multinational, or at the very least not domiciled in Canada, and that certainly complicates things for estate administration. How do you work around that?
Boy, you want to go deep fast, don't you, Tim? Yes. That is going to be a very interesting challenge as the industry navigates that. So we don't all have answers on those kinds of questions right now, right? So, but what I can tell you is from what I've seen in some situations. So one of the interesting things if we want to take a difference between Canada and US, and we want to consider that a lot of platforms sit in the US, and a lot of platforms sit in California. So in the US, I think the majority of the US states, I think 46 of the US states have adopted a law It's called Uniform Fiduciary Access to Digital Asset Acts, revised or not revised version. So this law basically tells an executor what they're allowed to do. Okay. And in the US, this RFADA that's implemented in most US states outlines what a fiduciary executor is allowed to do with certain kinds of digital assets, and they are allowed to access some of them. But any digital assets that have anything to do with communication, we're talking email, social media, and what platform doesn't have some sort of communication tag to it, requires a directive to be provided during life. And it also has a hierarchy of what rules what. Is it the will? Is it an online tool? Is it a separate thing? This is a significant, in my opinion, from a technical management planning perspective, departure from what we're used to. We're used to that the executor can step into your shoes. Now, in Canada, they have a proposed uniform law as well. It was proposed in 2016. It's only being implemented in Saskatchewan. And the Canadian uniform law generally is that executor is allowed to step into the deceased shoes and do everything the deceased was allowed to do. The challenge, as you're pointing out here, is these companies generally are located in the US. And what we've seen with things like Google and Facebook is they require court orders to access if you've not used the pre-planning tools. And we've seen that in the Miss Henry case and a few other cases globally. So even as a Canadian, we have to consider the situs. Again, back to my favorite domains, when people ask me about their domains, I ask them to consider from just a planning perspective, considering the situs, which is the location of the provider. Can you get a Canadian registrant instead of a US registrant? And have you asked, if you're going to continue with the US registrant, have you asked, phone their customer service, gone online, tried to figure out what is required upon death of the account holder, right? So again, another planning consideration. There may be reasons to use US providers or US registrants versus Canadian registrants, or maybe the platforms are there, but this is a serious consideration. So we are affected by where these things are located.
So this brings to mind the creature that I think Tim Ferriss invented, which is the digital nomad, which has become popular over the last 10 years, a popular lifestyle. And I would say almost certainly during COVID, people have realized, well, I can work from anywhere, at least in many jobs. And so I can see it becoming very complicated where you might have a Canadian citizen living in Poland who's got a service in California. It's very thorny. So I think you're really raising the point that, one, we need our vendors to kind of think that through for us. And then two, we need to look into what solutions they have to provide. It's a lot to consider, especially for a digital nomad where they will literally not have a filing cabinet.
Right. And I think this is one of the major tenant differences in planning our digital estates or our digital assets than our physical property rights, because we have 100 plus years of estate and succession law in various jurisdictions that defines what happens to property in various jurisdictions. And we don't have that benefit with digital assets. And so there is a need for all of us to, and that's why I keep bringing it back to the three significant ones, because if you start to look at your whole footprint, you might just say, I don't have time for this and I'm not going to bother. So the digital nomad, again, has a little more estate planning to do with their digital lives. And I do recommend seeking legal advice and tax advice in terms of that important question of where they're considered to be living, because that will affect where they're considered to have died. And again, it's going to depend on what footprint they have and what they want to do with it.
So let's bring it a little bit more down to earth and say, where should I keep my will so that it's both safe and easy to find?
That's a great question. When you get a will done with whatever provider you use or a state lawyer, I would certainly ask them. The common places people do leave them is a safety deposit box, but the number of people that have safety deposit box is becoming less and less. So it's a really good question. And something I'd ask a legal advisor when you get one done.
Okay. What happens when I Google something, as I almost always get told to buy an app? Should I rely on an app for estate planning? Are there any good ones?
That's a really good question. That's outside my technical realm from a management perspective, but certainly there is a growing amount of providers online. Now, what's important from a consumer perspective is you have to decide what's appropriate for your own circumstances, what risk you're prepared to take. Like you said, if you Googled wills years ago, there was more fear because you didn't know if you were using the correct template. So you want to make sure that you're using the correct template when you start that process. And many provincial organizations often have legal advice that you can get just to get started, to send you in the right direction. And I'd certainly encourage people to reach out if that's possible in their jurisdiction.
So this may also be an overreach, but I think we should explore it a little bit. The idea of a digital will and even possibly keeping it on a blockchain. Do you see technologies emerging that might make things a little easier that way?
Really good question. So if I sort of give you a sort of landscape of where things are at on that, the idea of a will being digital, the terminology that people are using is electronic wills. So it's electronic will legislation. Many jurisdictions in the world are contemplating the idea of an electronic will. In fact, in the US, I think there are several US states that have passed legislation that recognizes and allows electronic wills. It's going to be interesting from an IT journey. I do see this as the future, and I think electronic wills will change everything as part of the big digitization of the state industry. If we just take this back to basic data, if you think about the data entry that goes on in terms of information that's collected to create the will, and if you create a digital form, it's going to integrate estate planning and estate administration in a way has never been integrated before. But from a technology management point of view, I think it's a big system enterprise project to build a system that will be able to deal with this, right? So each jurisdiction is going to have to contemplate all the, you and I would use the terms non-functional requirements, like what are the legal formalities around a will, right? Then we're going to have to consider all the those are the functional requirements. Then we're going to have to consider all the non-functional requirements. Can we build a system that will scale to address a population of wills, and how will that process work with the courts? So this is a whole requirements gathering process and a design consideration that each jurisdiction is going to have to contemplate after these electronic wills are actually allowed to be and legislated. And then we've got obviously the interjurisdictional usages. Now, not to presuppose the technical architecture, I'm absolutely sure there's going to be a registry in there and, blockchain, there's different ways that could be contemplated as we start to think about that data integration from the client front end all the way through the back end court processes like probate. So I do see a future world where, some technology will be applied, whether that's blockchain or not will depend on what ended up being architected. But yeah.
One of the example I would use is the manufacturing of and design of cars, automobiles. Because it's so expensive to get that right, there's a tendency for jurisdictions, and at least smaller jurisdictions, to accept whatever the Americans impose as a standard for bumpers and safety and seatbelts and emissions and that kind of thing. It's just easier. And do you see pressure on jurisdictions to sort of homogenize around a single set of requirements for a what you refer to as an electronic will?
I think that will happen with the non-functional requirements. So the things like how is it going to scale and how is it going to work, and how is it going to be how are things interjurisdictionally going to work? But I think for the functional requirements, like the formalities and the legal considerations, that's going to be interesting, right? Because today we know each province has estate and succession law that's different from another province, right? I mean, there's some general principles you could certainly extract from there in terms of, we know that there's an executor or estate trustee, and we know there's certain kinds of roles. But so I see, the need to start to think about those non-functional requirements are going to have interjurisdictional conversations. And I know from building large enterprise systems with IBM that that's possible, right? That you can build a system. When I think of some of the systems I was the project manager for, in terms of, can we build an SAP-like system that's configurable for multiple jurisdictions? that allows you to address your jurisdictional differences, but then still have some underlying architecture that deals with your non-functional. So I think that's the way it's gonna play it out.
Right. So back in the day, my dad would etch his social insurance number on just about everything he owned, because the big risk back then was somebody's going to steal your lawnmower, not your identity, right?
Right.
One thing that blew my mind that I've heard you talk about is this idea of obituary identity theft. Can you expand on that and talk about how we can avoid that?
Yes, as you can appreciate, when you start to look at things from a technology cybersecurity perspective, and then you look at the amount of data that's in an obituary, it does become a bit alarming that we're giving away. It's unfortunate, because I know the genealogy crowd relies a lot on obituaries for information in terms of the research for historical, cultural, and family reasons, right? But we do need to start being careful. And the biggest consideration that we need to be aware of is the fact that, obituary in the past used to be quite short and probably only in the local paper. But our obituary now is online globally. So that just opens the door to identity theft. AARP has an interesting statistic. It's probably dated a couple of years, but it's still relevant. They say 800,000 Americans a year have their identity stolen after death. So if you kind of extract that to the Canadian population relative size, you're talking 80,000 Canadians, right? So I think we're going to have an eye to how much information we put in obituaries to reduce that risk.
So in addition to protecting our identity when we're gone, we need to protect our privacy. That there's this piñata full of love letters and photos and everything else that's going on in our life. How do we protect our privacy when we're gone?
That's a really good question, with difficulty, right? Our privacy after death is going to largely be dependent, and so far it is now, upon our privacy during life, right? So that example I gave you about your Facebook profile, if your settings are open now, they're going to remain open on death. So I think we have to first have an eye to our digital lifestyle now in terms of what our privacy is, so that at least we have that first thing. And then post-mortem privacy laws, again, have to continue to emerge, right? So, and we when we think of some of the avatars that have emerged of people after they've died, like who controls that? Who owns that? Again, those are a lot of legal questions that haven't yet been sorted, but things we'll have to contemplate. But while we're waiting for things to happen, we can clean up our digital lives while we're living to start that privacy conversation.
So you have first of all, it's a very impressive career history, right? You've got your project management professional designation, your professional engineering designation. You've been in the military. What were you doing in the military?
I was very privileged to serve. I was in the Royal Canadian Air Force, so served as a Canadian Forces member. I was in the aerospace engineering branch. So my specialty was software. So I spent most of my time in Cold Lake, Alberta with the fighter jets, which was a fantastic experience. And I was looking after the test equipment, which had software on electronic warfare and inertial navigation. So really at the front line of what these fighter jets were used for, which was tremendous. And then the back half of my military career was looking after the systems that looked after the parts. So the management information systems aspect of it. So I got both worlds of software, embedded system software on the front end, and then, the maintenance world on the back end. So it was really, really neat experience.
Yeah. And such a diverse career. It's very impressive. What was your process for writing and publishing the book?
The process, well, I certainly reached out to other people who had written a book, and there's a wealth of information online in terms of how do you write a book. But so I got some really good advice about how to go about it, and I evaluated a number of different ways that one could get published. As you know, you can go through a publisher or you could self-publish. And given the topic, I figured I'd self-publish to start. Because I wasn't sure if people were interested in the topic 4 years ago now. Obviously, it's become quite relevant, and just tackled it like a project. So you build a project plan in terms of getting the manuscript done, and I learned all about the various types of editing that are available, and I had some wonderful editors help me to to get the book into a readable format. And then I ended up choosing to publish in two ways for the first book. One was Friesen Press. And then I've published second book as Friesen Press. And I'm working on my third book with Jennifer Ziegel, a case study for digital assets. And we will be using a publisher this time around.
So this has been a fascinating conversation. It's very valuable. I do appreciate you taking the time to share with me and people watching. My last question is, it's inspirational that you took a difficulty you had administering and what must have been painful at the time, administering your mother's estate, especially with her being intestate, as you point out, and you turned that into a book that benefited so many. So thank you for that. Do you sometimes feel overwhelmed by the scope of what is yet to be accomplished in making the last part of life a little bit better?
It's a big topic area for sure, but I have been so privileged to meet some wonderful people through the Society of Trust and Estate Practitioners. I feel like I have as big a network I have now that I had when I was in the military or at IBM. So there's a lot of people who are really interested in trying to help clients on this topic. So I've been very privileged to work with that. So I feel like I have my own club now in this space, sharing information and trying to sort it out for people. So I've definitely been enjoying this aspect of my career right now.
Terrific. Sharon, thank you so much for being on the show.
Great. Thanks so much, Tim.
My guest today was Sharon Hartung. A link to Sharon's book titled Digital Undertaker will be in the show notes. My name is Tim Hampton, and you can reach me at tim@unusuallywellinformed.com. Thanks for listening. I hope you'll subscribe and join me for the next show with another unusually well-informed leader in business and technology.
Thank you for listening to the Unusually Well-Informed podcast.
The opinions expressed by the host and guests on the Unusually Well-Informed podcast are their own and do not reflect that of their employer or any other affiliation.